But we begin this hour with the aftermath of this week's Karen Read verdict, because we are now hearing from two jurors who are speaking out. The jury decided to find Read not guilty of second-degree murder and manslaughter and leaving the scene. This all happened on Wednesday, and it remains a fiery debate as to what these jurors were deliberating about. What were they stuck on? Now, juror number 4 and juror number 11 are speaking out to different outlets, and they're talking about this panel's verdict. Juror number 4, who goes by the name of Jason, told TMZ why acquitting Karen Read seemed like the logical choice. Take a listen.
I think for the jurors, there's a mix of some people think that she was definitely innocent, and the other people, there was a lot of reasonable doubt, at least to where we didn't want to convict her. I can only speak for myself. I think that she was innocent. It's hard to tell exactly what people think deep down. There was a lot of things thrown at us, evidence. So it's hard to tell.
This juror named Jason said that they didn't take a straw poll at the very beginning, that they just really wanted to get into the evidence and see what everything said and where everyone stood. So let's bring in our guests to talk about this. Here to discuss, we have retired FBI Special Agent Jennifer Coffendorfer, criminal defense attorneys and former prosecutors Joe Tamburino and David Bruno with us here as well. Thank you all for being on. Jennifer, let me start with you. Our first time hearing from a juror in this case. What's standing out to you about how they reached their decision of not guilty and what they struggled with in terms of the prosecutor's case?
Well, there were two facts, if you will, that each of them said that were just unbelievable to me. Juror 4 said that he didn't believe the tail light was even broken. And juror number 11 said she didn't believe that Karen Read was even at the location at the time of the death. She said she was just there to drop him off. So it was clear to me that somehow the evidence that was in evidence just went over their heads, or they didn't pay attention to it. It also seemed that it was very probable they did not consider her statements, which, remember, was one of the questions that came in.
Yeah, and her statements were something that we all thought were going to weigh heavily in terms of perhaps a guilty verdict, not a not guilty verdict. Let's take a listen to another clip from Jason.
I don't know what happened. I don't know what happened to John. Really, I was only presented a limited scope of what happened at the night, and I could only base my opinion off of the evidence that was shown in the courtroom. So I don't really know if there was a cover-up or not. I know that's the big conspiracy about it, but I don't really know. All I know is that there was a lot of holes in the investigation.
Joe Tamburino, I'm not hearing, didn't hear in this interview with this juror any mention of those fragments of tail light that we thought would be very strong for them on John O'Keefe's body. It seemed that was not compelling for these jurors.
Well, good morning. Thanks for having me on. Yeah, I'm going to agree with Jennifer. He was only presented with just one piece of evidence, or whatever he said, limited evidence. What are you talking about? There was so much evidence presented in this case, weeks and weeks and weeks of evidence. But I just chalk this up to two things. Number one, what a powerful media campaign by Karen Read and her supporters. And number two, a bad decision by Judge Cannoni to allow Michael Proctor's text to come into evidence. They were clearly hearsay. She said, well, it goes to bias. Bias is not an exception to the hearsay rule. I don't know how she allowed that in, because what the defense was able to do with that is to have Michael Proctor in that courtroom, even though he never testified. It was a terrible ruling by the judge.
Well, we're going to talk a lot more about Michael Proctor, but David Bruno, back to these jurors. What is this revealing to you in terms of the reasons that they could not reach a conviction and decided an acquittal is fair? Because I'm also hearing the jurors, and we'll talk about juror number 11, but juror number 4 didn't just say there was reasonable doubt. He said Karen Read is innocent.
Yeah, pretty fascinating. Juror number 4 said that there were some that were on innocent and the rest were on they didn't prove it beyond a reasonable doubt. Another thing that jumped out to me on juror number 4's statements is the lack of search of the house. and the holes in the investigation. And he believed that there wasn't a collision with the motor vehicle, which was the crux of the defense's case. And the reason that he stated was the video of the vehicle that they had when it was brought into custody, that it was showing an illuminated light, and ultimately the light was completely destroyed. So look, I mean, this is proof beyond a reasonable doubt, highest burden, obviously, and it seems like they focused on the collision, lack of investigation. There were a couple things, but again, proof beyond a reasonable doubt. Next step is going to be that civil case, and I think it's going to come a little bit different in the civil case because of the lower standard.
Let's take a look at the other juror that we are seeing as speaking out, juror number 11. Jessica Machado on Substack said she spoke and had 10 questions for this juror. Her name, according to this interview, is Paula Prado. And she said, this is the juror speaking, to be completely honest, when she was asked about how they came to the decision of not guilty, and did you think that Karen Read killed John O'Keefe, she said, to be completely honest, on the first day of trial, as I observed Karen's demeanor in court, I was very suspicious. It felt like she was hiding something. Her confidence gave off an impression of arrogance. But over time, I came to understand that I was looking at a woman who had already lost so much. The fact that she was able to remain calm, composed, and actively involved in her own defense became something I admired. Jennifer Koffendorfer, we spent a lot of time talking about how involved she was in her defense. And sometimes that can be off-putting to jurors, but clearly here, at least this juror, felt that that showed that she was confident in her case.
Yeah, you know, you never know what a juror is going to perceive when they see Karen Read in this trial, and any defendant. You know, for the angles we could see, and remember, they have a very limited angle of what they can see. And then they also can't see her facial expressions and those outbursts that she would have when the jury wasn't seated. So she had a limited view. She made her decisions based on that, in part, it would seem. But, you know, personally, I couldn't disagree more. I thought in trial, she showed a very negative side, an unemotional side, a side that showed a coldness to the murder and to John O'Keefe's death.
Another thing I found interesting about juror number 11, something that I didn't know, is that she said that when she was going to deal with being on this jury for so long, the big issue was that she had 4 small kids. And she said that her dad came in from Brazil to help take care of them. And she said it helped her to relive what her life was like before she had kids when she was an attorney. But she said she wants to now learn more about American law, suggesting it seems that she was an attorney elsewhere. But David Bruno didn't know that someone with a legal background like that would be on this jury. I also want to show you something that was put in this Jessica's Substack of this interview, where she was asked about if she felt the judge favored either side at trial. And here was her response. She said, I wouldn't say favored, but especially during the defense's case, I noticed a lot more of the judge saying, I'll allow it, right after objections from the defense, but that she didn't feel the same way when the Commonwealth was doing that. Basically, she felt that they couldn't even get through Dr. Marie Russell, the dog bite expert's testimony, because there were so many objections from the Commonwealth. They didn't like that. Is that sometimes a strategy?
Oh, it's critical. I often say that you want to be a credible source in the courtroom, both for the fact finder and the jury when there's a jury. Like, yeah, making objections is important. And standing up and making them with conviction, stating legal basis, and also, I guess when the jury sees that they're being sustained and they're on the right side of the law, it brings credibility to the defense. And I think it's an excellent point of advocacy for lawyers looking at taking lessons from this case.
Joe Tamburino, what did you think about juror number 11 and what she had to reveal?
Well, the first thing about that is this whole thing with the legal background, and then, you know, not disclosing that. I mean, that's a major thing.
I don't know that she didn't disclose it. I don't know that she didn't disclose it, but I didn't know about it, but I didn't sit through jury selection. It could have been on a questionnaire somewhere.
Okay. Then fair enough, because if she did disclose it, that's fine. If she didn't, that's an issue. But, you know, the whole thing with making an objections is, and I agree with David, you have to make them in the right area. You have to make them intelligently. You have to state a basis for it. And yes, it does give a signal when you are when you're getting your objections sustained, which means the judge is agreeing with them. And many times judges will tell a jury that. They will say, look, objections are not evidence, but you're going to hear me say sustained or overruled. Sustained means I agree, and the person cannot say whatever it is. Overruled means I don't agree. So yes, the way you make objections and winning those objections, sure, the jury's going to consider that.
And we know this jury had a lot of criticism of how police, Michael Proctor, the lead investigator, did this investigation.